Welcome to the Judicial Committee of the Privy Council, where today we are hearing an appeal from Trinidad and Tobago in the case of National Stadium Grenada Corporation and NH International Caribbean Limited. Details of the case can be found on the Judicial Committee's website by following the link to cases and then to current cases. In the appeal, the appellant, NH International, is represented by Mr. James Ailiff, Queen's Counsel, and Mr. Simon Atkinson. The respondent, National Stadium Grenada Corporation, is represented by Mr. Simon Hughes, Queen's Counsel. Before we begin, I should introduce the other members of the board who are sitting with me on this appeal. First, Lord Lloyd Jones.
Good morning.
Lord Briggs.
Good morning.
Lady Arden.
Good morning.
And Lord Sales.
Good morning.
I should explain that because of the COVID-19 pandemic in the United Kingdom, we are hearing this appeal remotely instead of in the normal way in court. I'll now invite counsel for the appellant, Mr. Ailiff, to begin his submissions.
Thank you, my lord. As the committee will appreciate, this is an appeal from a decision of the Court of Appeal of Trinidad and Tobago in 2018, reversing the decision of the trial judge, Mr. Justice Rajkumar, given in 2011 in favour of the appellant. At bottom, what is at issue is who is entitled to the sum of $2.8 million that was frozen in 1999 and then placed in a joint account in 2005, and with interest now amounts to a sum in excess of $6.5 million. I know the committee will have spent time reviewing these statement of facts and issues in the parties' cases, as well as the judges below and the key underlying documents. And I will therefore try and keep my submissions as short and focused as I can. However, three factors mean that I will need to take a little bit more time than might normally be necessary. The first is that whilst many of the legal principles at issue here are straightforward, there is an area at the core of the case which is not entirely straightforward, and which has yet to be addressed in any detail by a modern court, certainly not at appellant level. This is the area of the principles governing when payments for a specified purpose will give rise to rights in favour of third parties. That's the first area of complexity. The second is that there is some degree of complexity in the factual background and the documentation. And finally, the judgments below, with the greatest respect, do not bring a great deal of clarity to the case. The judgment of first instance, which the appellant says is broadly correct, is nevertheless quite long and not always easy to follow. And the judgment of the Court of Appeal, in the appellant's respectful submission, veers off at an early stage on a misguided analysis, which not only omits reference to the relevant principles, but also ignores hugely relevant factual findings of the trial judge. Subject to any indication to the contrary from the committee, I propose to proceed as follows. I do not propose to say more about the factual background at this stage unless the committee would welcome a resume. The factual background will hopefully be reasonably clear from the statement of facts and issues and the cases. And I will need in due course to refer to the project documentation, which will provide an opportunity to clarify a few points about the arrangements. So I don't propose at this point to go into the factual background. Instead, I propose to take the following course, which will broadly follow the appellant's case, but hopefully avoiding unnecessary repetition and recitation. I will start with a few preliminary comments and observations of a general nature in relation to the case. I will then turn to address the applicable legal principles. I hope to be able to take most of these fairly shortly as they are addressed in the case, and I don't understand them to be contentious. but I would welcome the opportunity to dwell a little on the area of difficulty I mentioned earlier, the principles that govern when payments for a specified purpose will give rise to rights in a party who may benefit from those payments. This is important because this is where the appellant says the Court of Appeal went so wrong. And as I said, it's not an area that's been addressed in other cases, so there isn't a convenient repository of the principles in any decided case. After addressing the legal principles, I propose to address the relevant circumstances for the purpose of establishing the party's intentions in this case, which is the key issue in the case. Again, I hope to be able to take these fairly shortly as they are addressed in the case and in the first instance judgment, which I'll be turning to. But I will need to look at the first of those circumstances, the project documentation in some detail, just to clarify our submissions on that. Then I propose to turn to the judgments below, first instance and the Court of Appeal. I appreciate, of course, the committee will have studied these, but they are not easy, and I would welcome the opportunity to take the committee through them, not line by line, but in overview, to show how the judge at first instance dealt with the matter, and we say broadly correctly, and how the Court of Appeal dealt with the matter, and we say with respect in a misguided fashion. And finally, having done that, I propose to sum up with the appellant's case on each of the issues arising on the appeal, but I'm hopeful by that point I'll be able to take it fairly swiftly, simply drawing the threads together and picking up a few miscellaneous points.
I wonder, Mr. Ailiff, could I just raise with you 2 points relating to the project documentation? The first concerns the trust deed, which is referred to in the facility agreement. As far as I can see, we don't have a copy of that trust deed.
Yes, it's rather frustrating. We do have a copy, but it's exhibited to the version of the facility agreement that is scheduled to the Act. So
right,
I will take the committee to
it. So take us to it. That's fine.
It's not with the signed copy, but it is with the copy, which is, for all material purposes, I understand, identical in the copy scheduled to the Act, which gave approval for the arrangements.
The other matter was it had occurred to us that the prospectus or listing particulars on the basis of which the bondholders were invited to invest might be of some relevance. I don't know if these have been referred to at any point in the proceedings.
I don't believe they were referred to. That it's possible they were referred to below, but they didn't feature in the detailed submissions or the judge's findings. So my understanding is they haven't featured at any stage, and what we're dealing with is just the facility agreement and its annexures, which contain, as I will show you the committee, which do contain the terms of the bonds, the interim and the permanent bonds, which would have been what the investors were interested in.
Right, thank you.
So I propose to start then with an overview of just a few.
But the bondholders must have been told something, even if, because they were sophisticated investors, it was in very short form, and the security arrangements would be key.
That's certainly right. I would envisage imagine they were told something, and the security arrangements would be key.
So there must be something about, anyway. Maybe somebody could just inquire whether it was before the judge.
I'm sure that those listening in will, on my side, will check into that for my lady. Just before I turn to the points of overview, just on terminology, I'm going to be using the definitions and abbreviations in the statement of facts in our case. They sometimes differ from those below, but I hope it's clear what is being referred to. The points I'd like to just draw attention to are just general points of relevance importance, just to steer the committee in terms of understanding our case as I develop it. The first one is the issues. It's common ground that there are essentially 3 issues in the case and on the appeal. They've been summarised in the statement of facts and issues. They've been labelled the trust, the assignment and the entitlement issues. The trust issue is whether there was a trust of the loan monies in favour of the appellant to the extent necessary to meet sums falling due under the construction subcontract. The assignment issue is whether, if there was no such trust, there was an equitable assignment by whoever was entitled to the loan monies, whether that be ICS or NS, an assignment by whoever was entitled in favour of the appellant to the extent necessary to meet sums falling due under the construction subcontract. Now, I should just say, at first instance and before the Court of Appeal, the appellant's case was that the right to the monies lay with ICS, and thus the assignment was by ICS to the appellant. Now, the appellant maintains this position on appeal, but it also wishes to argue that if, contrary to its primary position, ICS had no right to the monies, and instead they belonged to NS, the respondent, as the respondent argues, there was an equitable assignment by NS to the appellant. That is a new case which the appellant seeks permission to raise on the appeal, as it is a pure point of law turning on exactly the same facts and matters as were an issue below. And its effect is to extend the appellant's arguments to cover all possible scenarios in terms of who had a right to the monies, namely ICS or NS. And as a consequence, it may not be strictly necessary to determine the issue of who, as between ICS and NS, had rights to the monies, because the same arguments apply to both. So that is the second issue. The third issue, the entitlement issue, is a fallback issue, which only arises if the appellant fails on the trust and assignment issue. There is then a question as to whether the respondent can lay claim to the funds at issue. Those are the three issues. Now, in my oral submission, all three are addressed in the appellant's case. In my oral submissions, I'm going to be focusing primarily on the first two, the trust and assignment issues, because they represent the heart of the case. And if the appellant is right on those issues, one never gets to the point where the entitlement issue arises. That isn't to say that the appellant doesn't have powerful points to make on the entitlement issue, as set out in its case, but those points will become readily apparent from its case on the first two issues. And I don't want to get bogged down in spending time addressing a scenario the appellant says just doesn't arise. The third introductory point I want to make is that there is no conflict or inconsistency between the trust and assignment approaches. There's nothing wrong with the appellant arguing for both a trust and an equitable assignment. They're simply two different legal routes via the same facts to the same conclusion, namely that the monies are held for the appellant. Indeed, the upshot of a finding of an equitable assignment is that the assignor holds the asset in question on trust for the assignee, and not surprisingly, the textbooks even refer to a declaration of trust by an assigner for an assignee as one way of accomplishing an equitable assignment. Now, I'm just flagging this up because the point was taken below, both at first instance and the Court of Appeal, that there was something intrinsically wrong with running these two arguments. And we say, and I'll make this good as we go through the legal principles, that there is nothing intrinsically wrong with this. I'm not suggesting that the two approaches necessarily collapse into one. There may be cases where it matters whether one is talking about a trust or an equitable assignment, but they are closely related and they achieve the same outcome. And we'll see the two approaches at work in the cases dealing with payments for specific purposes. The fourth point, general point I'd like to make is the key role of intention. When considering the trust and assignment issues, the key question, as will be apparent from the appellant's case and I'll be developing in due course, is the intention of the parties. Did they have an intention to benefit the appellant in a way which the law will recognise as being sufficient to give to a trust or equitable assignment? And so I'll be focusing particularly on that issue. That's not to say that there aren't other issues such as consideration, formality, certainty, but that issue of intention is at the heart of the case. If the appellant fails on that, then it must fail on the trust and assignment issues. If it succeeds on that, the appellant submits that the other issues that arise can be disposed of really quite quickly. The fifth point, introductory point, is just to flag up who we say the relevant parties are when considering intention. Whose intention are we concerned with? We say the relevant parties are ICS and NS. ICS was the overall developer and set up NS to hold the site and borrow the monies to finance the project. And between them, they are the entities who, but for the appellant's claim, would be entitled to the loan proceeds. There is an issue as to which one of them is the better claim. The respondent says it does, and the appellant says ICS does, but that can be pushed to one side if they both had the necessary intention. So ICS and NS are relevant. Also relevant is CIB, the lender, in the sense that it was the entity making the loan and it held the loan proceeds when the advances were made. It claims no interest in the monies itself, but as it held the loan, the monies, its understanding and intention is relevant. And finally, the appellant itself, of course, its intention is obviously relevant as the entity claiming the benefit of the monies. The appellant says that the relevant, potentially relevant parties don't, for the purposes of considering intention, don't include the investors or the bondholders. I'll address that in more detail, and it may not matter a great deal, but the appellant's position is that once the advances were made, the investors, the drop out of the picture, they get bonds issued to them, and they have rights under those bonds, including a right to repayment in the event of non-compliance with the loan terms, but they no longer have any proprietary interest in the monies. This is important because the Court of Appeal became, we submit, overly focused on the position of the, if I may call them the investors, the persons who became the bondholders, but that was as a result of their misguided approach by reference to the quis trust principles, which involved them looking for a resulting trust and therefore focusing on the persons with whom the monies originated. We say that when one clears that away, that misunderstanding, the need to focus on the bondholders as relevant parties also falls away. The sixth point, general point I would like to draw attention to is that when ascertaining the intention of the parties for the purposes of finding intention, the court may look at all the relevant circumstances, not merely the formal written contracts. Now, of course, the contents of those contracts must be respected, but there is no reason in principle why the court cannot have regard to other matters if they help cast light on the intentions of the parties. Now, in the present case, as the committee will appreciate from the appellant's case, the appellant relies upon the project documentation, but not just that, it also relies and has always relied on a number of other relevant circumstances, oral agreements, conduct, and the committee will have seen the summary of the relevant circumstances relied upon.
What about the commercial rationale of the situation? We have a situation where the contractor was dealing with a shell company. Are there matters that we can take into account as in this situation? Is it normal for the contractor to be concerned if the developer stroke head contractor is a shell?
Well, in our submission, yes, very much so. It is relevant to be concerned about that because the contractor, my client, was mobilizing in a foreign, what was for it, a foreign jurisdiction, undertaking substantial works. And it was concerned, and we will see this particularly when we go through the judgment of first instance, it was concerned to obtain assurances right from the start as to how the project was going to be funded, financed, and that it should have a direct right to payment of monies falling due to it, without having to call on those shell companies. Well, one's a shell and the other's a substantial company. Well, actually, I'm not sure. I think my lady is right. It was a shell as well as it was established just for this project. So the appellant was very concerned about that. And indeed, the judge finds that to be a relevant circumstance, amongst others. So just two final points before I turn to the legal principles, just general points. This is, I think, my seventh point. The point I want to make here is that the reliance upon matters other than the project documentation doesn't involve any change or widening or extension of the appellant's case. I mention this because the respondent in its case suggests that these are matters that were not raised before the Court of Appeal, were not raised before the judge. That is emphatically not the case. I will substantiate this in due course, but the appellant's case has been built on a wide range of circumstances from the very start. Its statement of claim referred to the oral agreement and built its case on the oral agreement. This has been understood from the very beginning, and we'll see that the judge at first instance understood that. So it is not correct to suggest that what is now being alleged is in any way an extension of the appellant's case. Now, it is true that the Court of Appeal's judgment gives the impression that everyone, the parties and the judge at first instance, have been approaching matters on the basis that all that needed to be looked at was the project documentation. But that is simply not correct, as I will demonstrate. And the final introductory point, which I know is the main flaw in the Court of Appeal's approach, and I know the committee will have a good grasp of the basis of our challenge from the case and the comments I've just made, but just to briefly summarise what the appellant is saying is the main flaw in the Court of Appeal's approach. The Court of Appeal wrongly took the view, we say, on the trust issue, that what the appellant was arguing for was a quis trust, as strictly understood in the light of Twin Cetra, namely a resulting trust. And this led it to ask the wrong questions and to look at the wrong materials in addressing the trust issue. The core issue that the Court of Appeal ought to address was the intention of the parties to be gathered from all the circumstances, but instead it embarked on a narrow inquiry as to the purpose of the facility agreement and whether it was fulfilled, and regarded the intentions of the parties as, I quote, irrelevant, which isn't surprising, as it was looking for a resulting trust. And as the committee will appreciate, a resulting trust arises by operation of law regardless of the intentions of the parties. Although there may be cases where an arrangement similar to a resulting trust is expressly intended, but the strict resulting trust arises independent of intentions. And this misconceived approach to the trust issue by the Court of Appeal also led to it dismissing the assignment argument, because the principal plank of its dismissal of the assignment argument was that there was no interest had arisen in favour of ICS, because on its findings on the quis trust argument, no trust had arisen in favour of anyone, whether it be the appellant or ICS. So with those general introductory points, I now propose to turn to the legal principles. Unless the committee would welcome assistance, I don't intend to dwell on the basic principles governing the creation of express trusts and equitable assignments. These are covered in paragraphs 5 to 13 and 14 to 24 of the appellant's case. And it's not understood that there is any dispute regarding these principles. Certainly none has been identified in the respondent's case. The core issue is, of course, the issue of intention, and indeed the respondent agrees in its case at paragraph 37(1) that the central issue is whether there was an intention to create a trust. But I would just like to make one small point of clarification regarding trusts. Where we have referred to trusts and to express trusts, that is intended to include not only the classic express trusts of the kind I declare that I hold on trust for, and so on, but all trusts which depend upon the intention of the settlor. And that includes trusts based upon the presumed intention of the settlor to be gathered from all the circumstances, including statements of the settlor or conduct. Now, one might, in some circumstances, describe such a trust as an implied trust or an inferred trust, but we're treating all those kinds of trusts which depend upon intention as express trusts, and they're to be contrasted with trusts implied by law, such as resulting trusts or constructive trusts. What I would like to spend a little more time on, if the committee will permit me, is on the principles governing quis trusts and arrangements involving the payment of monies to a person for a purpose, such as paying paying creditors. This is important for two reasons. Firstly, as I mentioned earlier, it is in the understanding and application of these principles that the Court of Appeal erred so seriously. And also, as I indicated earlier, there is a marked lack of authority confirming and clarifying the applicable principles in this area. So if I may just start with quis-close trusts, properly so called, we've addressed these in paragraphs 25 to 31 of the appellant's case. As the committee will appreciate, that the basic factual scenario for a quis-close trust is a payment of monies to a person with instructions to apply them for a particular purpose, e.g. paying a debt. In such a scenario, the payer may argue that the monies are subject to a trust, requiring them to be repaid to him if they are not used for the specified purpose. And this may be important, for example, if the recipient becomes insolvent before using them for that purpose. Now, the first modern case considering that argument was the well-known House of Lords case of Barclays Bank and quis-close in 1970. And that was then followed by a number of other cases which wrestled with the underlying principles. Fortunately, it's unnecessary to look at the Barclays Bank case or the subsequent cases because the principles were considered again by the House of Lords in the Twin Sector case in 2002. And in that case, as I know the committee will be fully aware, that the House of Lords, and in particular Lord Hoffman and to a greater extent Lord Millett, clarified that properly analysed, a quis-close trust is a resulting trust for the benefit of the payer with a power for the payee to apply the monies for the specified purpose. And that the trust arises at the time of payment and it continues until the purpose is carried out. And if the purpose isn't carried out or fails, it remains in existence until the monies are paid to the payer. And it arises by operation of law to fill a void in the beneficial ownership of the money or assets. Now, there may be cases where the parties have expressly agreed or intend that there should be a resulting trust, that there should be a trust for the payer. That would be an express trust, not a quis-close trust. Now, if the committee will permit me, I would like to go to Twin Sector just to look at the analysis of Lord Millett. I'll try and take it as quickly as I can. It's in at tab 11 of the primary authorities bundle. The particular facts of the case are not particularly important. The committee, I'm sure, will recall that it's a case where a lender advanced monies for the purchase of land, specifically just for the purchase of land, and the monies were then misapplied, and the lender brought a claim against a solicitor who had given an undertaking to use the monies solely for that purpose. Two issues arose. The first was whether there was a resulting trust, a quis-close trust for the lender, and the second was, if there was, whether the solicitor had dishonestly assisted in a breach of that trust. Now, if I may pick up the analysis at paragraph 67 of the judgment of Lord Millett. Where Lord Millett refers to the Court of Appeal having allowed Twin Sector's appeal and holding that there was a trust.
Mr. Ailiff, I hope you're going to give us electronic bundle numbers, page numbers.
Oh, I'm sorry, I haven't been doing that.
It's 1412.
1412 of the hard copy.
And also the electronic copy.
I'm very grateful. Thank you, Mr. Hughes. And Lord Millett then turns at paragraph 68 under the heading, was there a quis-close trust, to consider the principles applicable here, and refers at 69 to the quis-close case itself. And then he turns at paragraph 70 to deal with the objections that were being raised in the case before him to the existence of a quis-close trust. they were essentially fourfold. Mr. Leach for the solicitors says that firstly, there was a lack of necessary intention to create a trust. Secondly, he says, he refers to commercial considerations and says there was no basis for an inference, this is at the bottom of the page, that the money was held in trust. And then he says over the page that a trust requires certainty of objects, and this was lacking. And finally, he says that no trust arose, in this case, prior to the could arise prior to the failure of the stated purpose, and that never happened. Lord Millett then turns at paragraph 71 to dispose, and 72 to dispose of the first two objections, and points out that subjective intentions are irrelevant. I don't need to dwell on that. And then Lord Millett turns to make 73 onwards a few further comments about quis-close trusts. If I could just draw attention to a couple of points. Beginning of 73, Lord Millett explains that a quis-close trust does not necessarily arise merely because money is paid for a particular purpose. And then he says at the beginning of 74, the question in every case is whether the parties intended the money to be at the free disposal of the recipient. And then picking his judgment up on the next page, page 14, 1415, paragraph 77, he turns to the latter two objections that have been raised and says they cannot be so easily disposed of, and they call for an exploration of the true nature of the quis-close trust, and in particular the location of the beneficial interest while the purpose is still capable of being carried out. And he notes that this has been the subject of much academic debate, and that the starting point is provided by two passages in Lord Wilberforce's speech in the quis-close case. And if I could just ask the committee just to quickly read the two passages that are quoted from the speech of Lord Wilberforce. And then Lord Millett picks it up in his speech at 79, paragraph 79, suggesting pointing out these passages suggest that there are two successive trusts, a primary trust for payment to identifiable beneficiaries such as creditors or shareholders, and a secondary trust in favour of the lender arising on the failure of the primary trust. But Lord Millett then points out that there are formidable difficulties in this analysis which has little academic support. What if the primary trust is not for an identical purpose, but in the present case to carry out an abstract purpose? Where in such a case is the beneficial interest pending the application of the monies? And he points to there being four possibilities: the lender, the borrower, the contemplated beneficiary, and in suspense. And Lord Millett then turns to deal with each of these. Now, I don't propose to take up time dwelling on each one. He deals first with the lender at paragraph 80 onwards, then over the page, paragraph 85, I beg your pardon, at the bottom of the page, paragraph 82, he deals with the borrower. And then over the page 85, he deals with the contemplated beneficiary and points out that in the quis-close case and all the reported case which preceded it, this hadn't really been in the issue. The issue had been the interest of the payer. It hadn't been necessary to explore the position while the primary trust was still capable of being carried out. But he then refers to the case of Northern Developments Holdings, where there was a holding that the contemplated beneficiary, the third party, did get an interest. In that case, as it's explained in paragraph 86 of Lord Millett's judgment, explains the facts. In essence, there had been a loan to a parent company to enable the payment of creditors of the subsidiary of that parent. And in that case, picking up at the bottom, paragraph 86, that then Sir Robert McGarry VC had held that there was a primary trust, and the primary trust was a purpose trust enforceable inter alia by the subsidiary's creditors as the persons for whose benefit the trust was created. So there was a finding that the third parties did acquire an interest. But Lord Millett at paragraph 87 says there are several difficulties with this analysis. And he goes on to explain some of those difficulties. But he does, at the end of that paragraph, just over the page at B, conclude that there was, nevertheless, he says there is a powerful argument for saying that the result of the arrangements was to vest a beneficial interest in the subsidiary from the start. If so, then this was not a quis-close trust at all. So just pausing there, what Lord Millett is saying is that one could justify the result there because there was an intention by the payer to give the subsidiary an interest, and therefore it would be an express, if that's the case, it would be an express trust in favour of the subsidiary, but there wasn't a basis for finding a trust in favour of the creditors themselves. But that's all that is said at this point in Twin Sectra about the interests of third parties. It wasn't the issue in Twin Sectra. The issue in Twin Sectra was whether there was a resulting trust for the payer. The issues of third parties didn't arise in the case. It's only addressed in passing by Lord Millett as part of his analysis of how a quis-close trust works. Then paragraph 90, Lord Millett addresses the alternative of the beneficial interest being held in suspense. I'm not going to dwell on this. I'm going to move on to the conclusion, but just to show your lordship, the committee, how we get there. At 93, Lord Millett turns to the Court of Appeal's analysis. And then if I can pick it up 2 pages further on, at paragraph 100 on page 1421 of the bundle, we have the conclusion where Lord Millett says, as Sherlock Holmes reminded Dr. Watson, when you have eliminated the impossible, whatever remains, however improbable, must be the truth. I would reject all the alternative analyses, which I find unconvincing for the reasons I have endeavoured to explain, and hold the quis-close trust to be an entirely orthodox example of the kind of default trust known as a resulting trust. The lender pays the money to the borrower by way of loan, but he does not part with the entire beneficial interest in the money, and insofar as he does not, it is held on resulting trust for the lender from the outset. Contrary to the opinion of the Court of Appeal, it is the borrower who has very limited use of the money, being obliged to apply it for the stated purpose or return it. He has no beneficial interest in the money, which remains throughout in the lender, subject only to the borrower's power or duty to apply the money in accordance with the lender's instructions. When the purpose fails, the money is returnable to the lender, not under some new trust in his favour, which only comes into being on the failure of the purpose, but because the resulting trust in his favour is no longer subject to any power on the part of the borrower to make use of the money. Whether the borrower is obliged to apply the money for the stated purpose or merely at liberty to do so, and whether the lender can countermand the borrower's mandate while it's still capable of being carried out, must depend upon the circumstances of a particular case. And if I may finally draw the committee's attention to the last sentence of paragraph 102 on the same page, where Lord Millett explains that it is a default trust which fills the gap when some part of the beneficial interest is undisposed of and prevents it from being in suspense. Now, pausing here and applying those principles, the appellant in the present case was plainly not arguing for a quis-close trust in this sense. Such a trust, being a resulting trust, wouldn't assist the appellant because it wasn't providing the monies. What the appellant was arguing for was an express trust in its favour. But as the factual scenario was in some respects analogous to scenarios which give rise to quis-close trusts, the argument naturally involved reference to the quis-close line of authority. And so there was reference in below and in the Court of Appeal to the quis-close case and the other cases. But in referring to that line of authority, the appellant was not arguing for a quis-close trust in its favour, but an express trust in its favour. It's crucial to understand this because this is what the Court of Appeal failed to understand and where it went, we say, so wrong. So turning at this point to, well, what are the correct principles to be applied when addressing whether an express trust arose in favour of the appellant? The appellant submits they are the basic principles relating to express trusts and equitable assignments, which have been summarised in the appellant's case. However, a useful explanation and application of those principles can also be found in the quiz closed line of cases and related material, because from time to time these touch on the question of whether, and if so in what circumstances, the third parties involved will obtain rights to the monies. We've seen Lord Millet's comments on that in the Twin Sector case, but there are other materials. But surprisingly, there is, although this issue does arise from time to time, there is surprisingly no definitive statement of the principles governing this area. The appellant has gathered together in paragraphs 32 to 42 of its case what decided cases, English and Commonwealth, and other materials there are on the question, and put forward what it submits is the correct principles. That the heading in the case to that section is the payer's ability to revoke the arrangements. It might, with hindsight, it might have been clearer to just call that section rights of third parties. The reason for focusing on the payer's ability to revoke is because that is the issue, the way the issue is sometimes referred to, indeed in the older cases was referred to, but the core issue is the rights of third parties. That's what's an issue. And it may be helpful to describe the situation in terms of A, B, and C. A is the payer, B is the recipient, and C is the third party for whose benefit the monies are to be applied under the arrangements between A and B. And the question is, when, if ever, will C acquire rights to the monies? And the appellant submits the answer is that C will acquire rights to the monies in the situation summarised in paragraph 35 of the case. There are three situations. The first is where the intention of A is to benefit C in a way which would justify finding on general principles and express trust in favour of C. B is where the obvious intention of the arrangements would be frustrated if A were to retain a power of revocation. And the final one, the third one, is where C is a party to the arrangements or their existence is communicated to him. Now, the cases and materials which justify that summary of the principles, which are addressed in the case, comprise comprise an article on a quiz closed trust written by Lord Millet when he was still in practice as a silk in 1985. A handful of modern authorities, English and Commonwealth, which address the issue, but not in definitive terms, and a number of older authorities, which I hope I won't need to turn to, and some references in textbooks. Now, I'm going to go through those, not in a great deal of detail, but I would like to take the committee to the key points in those sources. The first is Lord Millet's 1985 article, which is at page in the final tab of the primary bundles at page, I hope, 1558.
We do have a much better copy of this as which was separately provided.
I'm so glad to hear that. I was going to raise that and say we had offered one. Unfortunately, when the bundles compiled, we just couldn't get into a library to get the copy, but we now have a copy. If I can take the committee to that, Lord Millet sets up.
You may have to wait a moment. You may have to wait a moment, I think, for some members of the board to find it. It's in the bundle for this case in our SharePoint file.
I see my Lord Briggs is raising his hand.
I was just saying the file is just called the Quiz Closed Trust. Who can enforce it?
Yeah.
I'm grateful. If I may start then, Lord Millet sets up the questions he's addressing on the first page of the article and the first paragraphs, explaining that he's looking at the situation of where there is a payment, a loan for a specific purpose of enabling payment of creditors or a class of them or for some other purpose. And the questions he's addressing include whether the creditors or any of them, C, can compel B to apply the money, and also where the beneficial interest is in the money. And he indicates at the beginning of the next paragraph, clearly the answer to these questions must depend upon the intentions of the parties. So he draws attention to that key point, but he submits that subject to that, in the absence of special circumstances, A is free to change his mind, for B's obligation is owed exclusively to A and not to C. And accordingly, as to the beneficial interest, he says, unless until finally disposed of either to B or to C, it must remain vested in A. So that's his answer to the question is subject to the party's intent. I'm sorry, I see Lord Briggs is raising his hand again.
It's me again. We know from Twin Sectra, don't we, that when Lord Millet speaks of the intentions of the parties, he doesn't mean subjective intention.
No.
No. And that's quite right, my lord. Subjective intentions are not relevant. Objective intentions are relevant here.
And that means, doesn't it, the intentions to be derived from what the parties, and in particular the settlor, if there is one, has written, signed up to, or manifested by his conduct, or said or manifested by his conduct.
Precisely, yes. And just picking up my lord's points there, it's objective intention. Intention is not relevant when looking for a quis close resulting trust, because it's a default trust imposed by operational law. Having said that, it is relevant in one respect, which is the first question when looking for a quis close trust is, did the parties intend the recipient of the monies to obtain title to them? And because if that's answered, if the parties did intend the recipient to obtain free disposal of the monies or asset, then a quis close trust won't arise. So it's a little confusing. Intention does have a little bit of a role in a quis close trust, but it's basically a default trust. Now, I don't need to take your lordship through the detail of this, the article, because there is quite a lengthy consideration of both the modern authorities, quis close and so on, but also a number of older authorities. But what matters for present purposes is that Lord Millet draws attention at various points to the circumstances in which C will obtain rights. And there are 3 or 4 points at which he does this. The first is at page of the bundle, it's 1572. The internal numbering, I'll just find out. It's page 283 of the bundle of the article. And the top paragraph.
We have that as page 15 in our bundle.
I'm grateful. It's a paragraph beginning, the fact is that there is no need for any unorthodox analysis of what, after all, is a simple commercial transaction of a not uncommon kind. He's saying this in the context of commenting on the Northern, I think he's commenting on the Northern Developments case. If indeed it is A's intention to confer enforceable rights on C, it is easy enough to give effect to it without creating another kind of enforceable purpose trust and without leaving the equitable interest in new bibis. If it was the bank's intention in the Northern Developments case to benefit Kelly's unsecured creditors, that was the subsidiary's unsecured creditors, then the proper way to give effect to that intention was to treat the arrangements made by the banks as constituting an irrevocable trust for the benefit of Kelly's unsecured creditors, enforceable by any of them by virtue of the beneficial interest in the trust property vested in them in a class. And then in the next paragraph, it may be helpful if I could invite the committee just to read the next paragraph as well. I won't take time by reciting it. In a nutshell, Lord Millet was there saying that the analysis in the Northern Developments case can't be supported, but the conclusion could be if the intention was to benefit either the subsidiary or the creditors themselves. You just find an ordinary trust principles, a direct trust in favour of them. And we say that is what one can do in the present case. If I can turn to the next passage of relevance, it's on internal numbering 285, but if the committee doesn't have that, I think it will be page 17. It's a page beginning at the top of the page in the two more recent cases. And then the relevant passage is the middle paragraph beginning, it does not follow, however, that the obligation is owed to or enforceable by C. Whether this is the case must again depend upon the manifestation of A's intentions collected from the language used, the conduct of the parties, and the circumstances of the case. If indeed it was his intention to benefit C, there is no difficulty in giving effect to that intention by treating the arrangements as constituting B a trustee of the fund for C. C will have a beneficial interest in the fund, and the fund will not in the ordinary way be irrevocable, and the fund will in the ordinary way be irrevocable by A and enforceable by C, but not by A. So we also would rely upon that. And then finally, at page, towards the end of the article, it's the penultimate page. I'm afraid it's internal numbering of the article of the Law Quarterly Review, 290. So the penultimate page. And the first full paragraph at the top of the page.
That's our page 22.
I'm grateful. The first full paragraph towards the top of the page begins, all this, of course, depends upon the absence of any communication to C, where C is a party to the arrangements or their existence is communicated to him, an irrevocable trust in C's favour is created. It is sometimes suggested that this results from an estoppel on the ground that there is no other ground on which upon which a trust initially revocable can subsequently become irrevocable, but this would seem to proceed from a misunderstanding of the true nature of the trust at its inception. If, as is here suggested, it is not a revocable trust for C, but a trust for A, then in accordance with the ordinary principles of communication, communication to C perfects an assignment of A's equitable interest to C and converts A's revocable mandate into an irrevocable trust for C. So here we see the Lord Minute drawing attention to the importance of communication of the arrangements to the third party. If that happens, that can give rise to a trust in favour of C by virtue of an equitable assignment of A's interest in the relevant asset to C. Or the alternative ground that has sometimes been used is estoppel, but Lord Millet suggests the correct analysis is equitable assignment. And in the footnotes, there's reference to various 19th century and early 20th century cases, which are in the bundle, but I don't propose to take your lordships to them. They do support, we submit, the points that Lord Millet is raising. I see my Lord Briggs is raising his hand.
Yes, I'm slightly troubled by your third supposedly self-standing heading of communication to C. If you look at, if the party's intention or the settled intention is encapsulated in a form of document which he has signed, and you conclude that there is an intention to confer an incidental benefit on C, but not to give C a beneficial interest in the subject matter, then can it make any difference that the contents of that document is communicated to C in the sense that he knows what it says?
With respect, I think it does make a difference. If A has committed himself to the use of the monies in that to payment to C, committed himself to B, and that arrangement is communicated to C, then it does result in an equitable assignment in favour of C. We submit that that is the case. And I can pick that, we will come back to this, we'll see it at work in some of the other materials. Just to finish this article, the final passage is done further down the page, the same page. Under the heading conclusion, Lord Millett starts with a submission that the quis close trust doesn't involve any departure from well-settled principles of law. If I can pick it up in the next sentence, the answer to the question raised at the beginning of the article depends upon A's intention to be collected from the language used, the conduct of the parties, and the circumstance of the case. The following, it is suggested, may be regarded as suitable guidelines by which A's intention may be ascertained. 1. If A's intention was to benefit C, or his object would be frustrated if he were to retain a power of revocation, the transaction will create an irrevocable trust in favour of C, enforceable by C, but not by A. The beneficial interest in the trust property will be in C, I beg your pardon. And then the third one is also relevant over the page, on the final page of the article, where A's object is to save B from bankruptcy by enabling him to pay his creditors. The prima facie inference is that set out in 2, which is that there is no interest in C. But wherever that is the correct inference, and then picking up Roman 3, communication to C of the arrangements prior to A's revocation will effect an assignment of A's equitable interest to C and convert A's revocable mandate into an irrevocable trust for C. So those are the key point passages in Lord Millett's article. Then if I may turn to the modern authorities, English and Commonwealth, such as they are, in date order. I mean, we have obviously Quis Close and Northern Developments, and there's also Correris Rothmans, which is mentioned in the Twin Sector case. I don't propose to go to those because we have the gist of the analysis in Twin Sector. If I could pick it up with the New Zealand case of General Communications and Development Finance Corporation, which is in the primary authorities bundle at page, I hope at page 1220.
Yes.
This case was referred to at first instance and in the Court of Appeal. And just very briefly, if I could invite the well, let me just summarise very briefly the facts. A lender advanced monies to a company to purchase equipment over which the lender would have security. The monies were to be paid in instalments to the company's solicitors for disbursement to the suppliers of the equipment. And the plaintiff in the case was a supplier. And the plaintiff contacted the lender to inform it of the proposal to supply the company, and obtained confirmation that the lender was providing finance and that the company's solicitors were responsible for disbursing that finance. The plaintiff then received a letter from the solicitor stating that on receipt of finance from the lender, they would pay the purchase price to the plaintiff. The arrangements between the lender and the company were subsequently changed, although the plaintiff wasn't informed of this, so that the monies were all paid up front to the solicitors, who undertook to the lender to disburse them to suppliers. After the plaintiff had supplied the equipment before payment became due, payment was due 90 days after supply, the company became insolvent. The lender asked the solicitors to repay the money to it, which the solicitors did. And the plaintiff then sued the lender and the solicitors, claiming that the monies had been held by the solicitors on trust for it. And the judge at first instance found for the plaintiff, and the matter was appealed to the New Zealand Court of Appeal. If I can pick up at page 1243. We find towards the bottom of 1243, heading the High Court judgment, and reference in the ultimate paragraph on the facts, Tompkins J, and then the Court of Appeal summarise the findings of the judge at first instance. Perhaps I can just pick up the last sentence beginning on the bottom of the page. Further, he held that it was the intention of DFC, that was the lender, Video Workshop was the company, and Mr. Shepherd was the solicitor, that the money was to be used and to be used only to pay suppliers, and that it could not be paid to the company, Video Workshop. And he concluded also that the arrangement was irrevocable. That was the basis of the trial judge's finding. And then the Court of Appeal proceeded to analyse the issues, and we'll see at the bottom of page 1244 references to Quis Close Trust. And if one scans through the next 2 or 3 pages, we will see references to the Quis Close case, the Northern Developments case, the Carreras-Rothmans case, Lord Millett's article. And then picking up the position on page 1247, the Court of Appeal concludes its analysis under the heading, did General Video acquire a beneficial interest? General Video was the supplier. And if I can pick up the reasoning at paragraph 45, it is clear from those terms that although this money did not have to be kept apart in a separate account, it was not to be part of the general assets of the company Video Workshop. And then he refers in the next sentence to no significance of being held in the solicitor's trust account rather than any other account. It's to be held there, but on terms which required it to be applied only in payment of the suppliers of the equipment. And then in the next one sentence, we therefore agree with Tompkins J that the terms upon which the solicitors received and held the money imposed on that firm a trust to apply it primarily in payment of the suppliers and secondarily in repayment of the lender. It was not a mere power to make those payments, but a duty to the lender, he's saying here. Then the next paragraph between 5 and 10, the Court of Appeal start to deal with the more difficult question is whether the beneficial interest in the money passed to the suppliers, enabling them to enforce the trust. Clearly, any such interest would be contingent on supply being made, but that contingency was realised in the case of General Video. The principle is clear, and these are perhaps the core findings in the judgment, the core statement of principle. The principle is clear. The beneficial interest will pass if such was the intention. The intention may be express, as where the arrangement is made for the stated purpose of benefiting the creditors, or it may be inferred, for example, from the nature of the arrangement. If the arrangement is such that its purpose would be defeated if the settler were able to revoke it at will, then it will be inferred that he intended to forego the beneficial interest that would have left that right with him. And then the Court of Appeal give an example of an arrangement of that kind, referring to a 19th century English case, which is one of the cases we've referred to. And then if I can pick up in the next paragraph, in his judgment in that case, Lord Eashel, Master of Rolls, adopted a lengthy passage from the judgment of Vice Chancellor Turner in Smith and Hurst, in which in the course of discussing the question of revocability, the latter had mentioned another cause of irrevocability, referring to the need to examine the circumstances in which the deed was executed in order to ascertain its true purpose. The Vice Chancellor said at page 47, and this examination does not stop with the deed itself, but must be carried on to what has subsequently occurred, because the party who has created the trust may, by his own conduct or by the obligations which he has permitted his trustee to contract, have created an equity against himself. Such an equity would arise from communication, for example, because creditors being aware of such a trust might be thereby induced to forbearance. And then the Court of Appeals with some references to some of the other 19th century and early 20th century English cases, which we again have referred to. Picking the judgment up at 45 on the same page, there was in the present case no communication to the suppliers of terms upon which the fund was paid to and held by the solicitors. But then he says in the next paragraph, in our opinion, Tompkins J was right in his conclusion, although we see in the relevant facts not just this one, but two circumstances which point to the enforceability of the trust at the instance of the supplier. And over the page, he deals with those two circumstances. It's trying to just cut through those two circumstances. The first can be seen at between 15 and 20 on that page. Although it did not know of the solicitor's undertaking, it had informed General Video, the supplier, that payment, General Communications, that should be, I think. It had informed General Communications that payment would be received through the solicitors. It had therefore made it clear to General Video that it would not have to rely on Video Workshop, the company, to pass on monies direct to it. When I say it is the lender, DFC. So the first point is that there is communication. 3 lines further on, the judge says that we think that by the advice given to General Video, DFC created an equity against itself that prevented it from varying the terms on which it later paid the fund. That circumstance was, we consider, sufficient to enable General Video to enforce the trust. So the first principle that's applied here is communication. The second is irrevocability, and that is dealt with in the final paragraph on this page. It might well be said that DFC, the lender, being contractually unable to recall the fund itself, save in the event of non-payment to a supplier, and being unable to allow payment to other than suppliers, the trust it created was for those reasons alone irrevocable. Be that as it may, we consider that in the circumstances, it must certainly be inferred that that was its intention. And if I can, he then continues to explain why he thinks that should be inferred in that case, and concludes at the end of the paragraph, having put the fund beyond its power of recall, we consider that it must have intended the trust, binding as it was on the solicitors, to be irrevocable, and hence to confer a beneficial interest on each supplier as he fulfilled his contract. So in a nutshell, we find here the New Zealand Court of Appeal applying the principles identified by Lord Millett in his article and supported in the 19th century case law to the facts before it, which are not a million miles away from the present case, and concluding that a trust was created in favour of the plaintiff supplier on 2 grounds. One, that the arrangement had been communicated to the plaintiff in circumstances which raised an equity preventing revocation, and secondly, because the lender must in any event have intended the arrangement to be irrevocable. So that is the General Communications case back in 1987. The next case in the line of authorities is then the twin sector case, which we've looked at, which didn't address directly the rights of the third party, but incidentally touched on it. And then we have a case called Re Margareta in 2005, which is in the primary authorities bundle at 1386. A decision of Michael Crystal QC, sitting as a deputy judge of the Chancery Division. In this case, we had a company sold property for around 4 million plus VAT if payable. Pending resolution of whether VAT was payable, the VAT was paid by the purchaser into the company's accountant's account from where it was misappropriated. The company in liquidation subsequently recovered the monies from the account, from among others, the accountant. And Customs and Excise argued that the money should be paid to them on the basis that the original monies had been held on trust for them, either under an express trust or what they called a quis-close trust. If I can pick it up at paragraph 9 of the judgment, towards the bottom, page 1388, we see the contentions of the Customs and Excise. It's only the first 2 grounds we're concerned with: express trust and a quis-close trust. As to express trust, the judge dealt with this at paragraph 11 to 14. and he held that there was no express trust because at the outset he says there's no express trust because it would be going too far on the facts to find that the payer intended to confer a benefit on the customs and excise. And he comments at paragraph 13, the question whether an express trust arises in the context of a commercial transaction is essentially one of looking at the intention of the parties established by reference to all the circumstances. In the present case, it's extremely unlikely that the purchaser would have wished to create an express trust in favour of customs and excise at the time of the transition of the monies. At that stage, it was unclear whether there would be a VAT liability at all. If there was not, the purchaser would obviously want the fund back. However, if the customs excise was the beneficiary under express trust ab initio, then its beneficial interest could not be defeated simply on the basis there was no VAT liability. So express trust failed, but then the judge had turned to consider the quis close trust argument, and picking it up at 23 onwards, the judge refers to Lord Millett's analysis in Twin Sectra, in which the usual conclusion is the monies remain vested in the donor. But then he points out at 24, that is not to say that there may not be situations where the intended payee under a quis close trust obtains a beneficial interest in the fund. These include situations where A, the obvious intention of the transaction would be frustrated if the donor were to retain a power of revocation of the trust, and he refers to the New Prance and Garrard's trustee case, and B, where the existence of the trust arrangements is communicated to the intended payee and the latter gains a beneficial interest in the money, either because of the creation of an estoppel in his favour or because communication perfects an assignment of the donor's equitable interest to him. And he cites the various 19th century and early 20th century cases, and also refers to Lord Millett's article. But then further down the page at 28, he comments that Customs and Excise became aware of the existence of the terms upon which the fund had been constituted at the latest on November the 26th, 1999, in a telephone conversation between its solicitor and a solicitor acting for the, I think that must be the purchaser. At this date, if not earlier, it is arguable that Customs and Excise would have obtained a beneficial interest in the fund in the light of the principles referred to. I see my Lady Arden is raising her hand here.
Question. No.
Sorry, thank you. In the light of the principles referred to at 24b above, but the fund did not then exist. It had been misappropriated. There was, however, the claim against Mr. Fox, that's the accountant, which was held on trust for whoever was beneficially interested in the fund. It would follow on this analysis that from that date onwards, the beneficial interest ownership of the claim against Mr. Fox belonged to Customs and Excise. And then he says it's not affected by the company's then financial state. And in paragraph 29, the final sentence, he concludes that they cannot hold those monies for the company beneficially, as the company never had any interest in the fund in the first place. Paragraph 30, in the present case, it can therefore fairly be said that the payments received from Mr. Fox would enable the misappropriated fund, the subject of the quis close trust, to be reconstituted in large part and thereafter used for the purpose for which it was designed, namely payment of the VAT to Customs and Excise. So there we have a decision applying these principles and finding by virtue of communication that the third party involved did get an enforceable interest in the monies in question.
It seems slightly curious because the communication wasn't by the donor of the monies, but by the by a solicitor acting for the other company involved in the property transaction. So that communication wouldn't set up wouldn't set up an estoppel against the donor, and it's difficult to see how it could affect an assignment of the donor's equitable interest.
I see your lordship's points on that.
Just an immediate reaction, not having read, obviously looked at this in any detail.
Yes, no, I see your lordship's points on that. I mean, I don't think it really matters from our point of view because we're simply relying upon these principles. It may be that actually they're properly analysed. These principles were extended beyond the narrow remit that we would say they work in, which is where you have communication by the parties who otherwise would have an interest in the monies. Here you have notice coming to the third party from some other source. I would need to work back, actually, I think, just to double check where that source was.
Could you imagine if I were to give monies to my solicitor for the payment of my creditors, and I make no communication with the creditor, but they happen to learn of this arrangement through some other source, it's difficult to see how that could deprive me of my right to revoke the mandate that I'd given to a solicitor.
Well, I do see that, and it's also would be difficult to see how that could be an equitable assignment.
Yes, quite.
Your interest. It may be either the explanation is that actually the party communicating was connected to the person who would otherwise have owned the monies. I would need, I'm afraid, a little bit of time to work back to it. But I don't think whatever the answer, if anything, it shows an even wider application of the principles, but it doesn't disturb the basic thrust of the principles that we rely upon. And if I may leave it there, I noticed my Lady Arden was raising her hand.
No, I was simply going to say that in the law of equitable assignment, it may be that notice does not have to be given. It has to be given, obviously, to the party charged, but doesn't necessarily have to be given by the party assigning.
That's a very good point.
It's another point.
If I may say with respect, that's a very good point. And actually, I should have thought of that, because an equitable assignment can be achieved either by communication of the by the assigner, the owner of the asset, saying I'm giving it to you, or by the owner directing the person holding it to pay it to C. Now, I think what one might say is here, underlying this whole arrangement, there is that direction to the person holding the asset to pay it to Customs and Excise, which would be sufficient for an equitable assignment. But that wouldn't, again, coming back to my Lord Reed's point, it still wouldn't quite work, because it wouldn't then be a case of communication. It would be a case of straightforward equitable assignment without communication.
Where I'm stuck is why it should be that an arrangement between A and B, which as created a trust, if at all, only in favour of A, should somehow turn into a trust enforceable by C merely because of communication to C. There must surely have to be something about the communication which makes it an assignment, i.e., which in substance discloses an attempt to transfer A's interest to C.
Yes, I think the communication must be of an arrangement under which the monies are to be paid to C. It must be something which would tie in with equitable assignment. It would have to be something that indicates that A wants B to deal with the asset in a way that benefits C.
Exclusively, and to the exclusion of himself.
To the exclusion of himself, yes. I think it means that you need enough to establish an equitable assignment.
Yes.
So
the communication route only works if it's an equitable assignment. And if it's an interest under a trust, it's an equitable assignment of an equitable interest too, isn't it? Because the legal interest is in B. So it may, and we're jumping ahead, give rise to statute of frauds issues. Yes,
my lord, that's correct. I think, dealing with your first point, I think that is right. It does come down to being a question of equitable assignment. It's not mere communication. It's a communication which amounts to an equitable assignment.
It's a communication by way of equitable assignment.
Exactly. On your lordship's second point, yes, I mean, if that were the correct analysis, but when that what's being assigned is an interest under a trust. But we would say, properly analysed here, you don't end up in that scenario. Well, there is one analysis in which you do, but most of the analysis you don't, because what's being transferred, what's being assigned is contractual rights. So, for example, if you're looking for an assignment from NS to the appellant, and this is happening, remember, before monies have been advanced, so it's before CIB is holding any monies. All there is a network of contractual arrangements. What NS is assigning is the benefit of the contractual promise it has, so that is a legal right. An issue may arise as to beneficial rights when one analyses it in terms of ICS being entitled to the monies, because then there are different ways of approaching that, and I'll come on to it. But then one way of looking at it is there is a trust for ICS of the benefit of the contractual rights, and that interest under that trust would be assigned.
But that's still going to be an assignment of inequitable shows, isn't it? That
would be right, but there is writing for that.
Okay.
There is a letter from ICS saying we assign. We'll come on to that.
Yeah.
We say those problems can be dealt with, but I think if I can keep focusing for now on the intention and the legal analysis governing trusts and equitable assignment, and then come on to those other points.
Now, Mr. Hilleth, I noticed the time. Would this be a convenient point for us to have a 5-minute adjournment?
My Lord, certainly, I have literally just 2 short points to make, and then I'm done with the legal stuff. So could I make these points and then?
Yes, certainly, certainly.
I've dealt then with all the authority that we have been able to unearth, modern authority, on this issue, even though it's one that does arise quite a lot. The older authority, the 19th and 20th century cases you've seen cited in the materials I've shown the committee, we've referred to in the case. I'm not proposing to go to them. We say they support what we say, and our analysis is in the case. The final source of material on the legal analysis is the current textbooks. And surprisingly, they also contain almost nothing by way of commentary on this situation. Lewin on trusts has a longest section on quis-close trusts at paragraphs 940 to 965, which focuses on twin sector and the analysis of quis-close trusts. And then there is a brief passage, I won't trouble the committee with it now, but there is a brief passage at paragraph 959, which addresses the interests of C and draws attention to the possibility of a direct trust in favour of C, and also draws attention to the possibility of C acquiring an interest through communication on the basis either of an estoppel or an equitable assignment, for which it cites the Re Margareta case. And Snell's equity has an even briefer reference. It's not in the bundle, but an even briefer reference at paragraph 2535 to the possibility of C obtaining an interest under ordinary trust principles, but it doesn't cite any authority for that. So that really is the sum total of the legal materials that we've been able to unearth on the principles that govern when C will obtain a right to the underlying monies. If that's at a convenient moment.
Yes, certainly, Mr. Hilleth, thank you. Well, we'll adjourn now and we'll resume in 5 minutes' time. What we'll do is simply mute our connection and turn off the video link. Yes, Mr. Hilleth, when you're ready.
Thank you, my lord. What I propose now to do is to turn to the circumstances which we say are relevant when ascertaining the parties' intentions in this case. Just before I do, just picking up 2 little points from the earlier session, Mr. Atkinson has just delved into the papers and just let me know that there was no prospectus, just to deal with my Lady Arden's point, there was no prospectus before the judge, at least at first instance. And the other point is that NPSL, in the Margareta case, NPSL was the other creditor in the liquidation of the company. There were 2 creditors, Customs and Excise, and the other one was NPSL. It was their solicitors that were right in giving notice of the arrangements. Turning therefore to the circumstances for ascertaining the parties' intentions, we have summarised these in the case, and the committee will appreciate that there are 5 relevant circumstances: the project documentation, the oral agreement, discussions and agreement, the June 1997 exchange of letters, the subsequent conduct of NS, ICS and CIB, and the subsequent conduct of NH. These have been summarised in the case, so I don't propose to dwell on them too long, but I should start by just going through the project documentation in a bit of detail to explain how we say this should be understood and to explain its significance. One important preliminary point is that the initial project documents are not the basis of the appellant's case, in the sense that it's not necessary to find the alleged trust and assignment from the initial project documentation, by which I mean the facility agreement, the memorandum of understanding, the development agreement. What the appellant says about those documents is that they set up a contractual landscape which sits comfortably and indeed contemplates the very arrangements which were later put in place when the construction agreement, the construction subcontract itself, was entered into. The key elements of that landscape were ICS was to be responsible for carrying out the project, including by creating NS to hold the land and borrow the monies to finance the project against the security of the land. The funds to be borrowed by NS from CIB were to be used only for the purpose of paying ICS and contractors from ICS. And to give effect to this purpose, CIB was to receive and hold the monies and to disperse them to ICS and subcontractors on receipt of appropriate invoices and certificates. And those elements of the landscape were sensible and protected everyone's interests. The government could rest assured that the monies would become available and be used to fund the project. CIB, and behind them the investors, the ultimate lenders, could rest assured that the monies would only be used to pay for the project and to produce the security they wanted. ICS could rest assured that funds would be available to it to meet the costs incurred by it in carrying out the project. And NS could rest assured that the project would be completed so as to give it the completed stadium, which it could then let to the government to generate the income to enable repayment of its borrowing. So viewed against this...
I didn't mean to interrupt. I was just going to say, I note that the lenders, the note holders rather, were given security over real property and over the lease. So if there had been an event of default, would they have any right to claim on the monies held by SIB in this special account?
No, they just had a right to repayment of the loan.
And when enforcing their security was only specific security. It wasn't a floating charge or anything of that nature.
No. It was, I will show you the committee the provisions, but no, the security was a charge over the land. Perhaps I should just explain this. The basic structure was the government would transfer the site to NS, who would then mortgage the site to CIB to secure the lending from the ultimate bondholders. So and then, sorry, when the project was complete, when the stadium was built, NS would let the stadium to the government, who would pay a rental, which would pay the interest and repay the loan. But the government also had a right to bring the lease to an end and recover the site by repaying all outstanding monies owed by NS. So those were the arrangements.
So the commercial financing of this project did not involve in any way the bondholders having expectations that they would be able to execute security over the CIB account.
No. No. So, which is why we say the bondholders to some extent can be ignored. I mean, yes, that's where the monies came from. And it may well be that when they first paid them to CIB for use in making the loan, there was a quis close trust, in the sense that if the monies were not used in making the loan, they were to be repaid to the investors, to the bondholders. But if they were used in making the loan, that was the end of the bondholders rights to the money. Thereafter, their rights were as set out in the bonds themselves, which included the right to repayment, the security, and so on. So if I see my Lord Sales has raised his hand.
Yes, thank you. It was just a question on the fact. In the statement of facts and issues, we're told that the government paid off the bonds at the end of the day. Was that pursuant to the arrangement that you've just described, that the government pays the bondholders, and by doing that, it has a right, as against NS, to acquire the site?
In a nutshell, yes. The arrangements are slightly more complicated and slightly odd the way they were done, but basically, and I would need to go back to the underlying documents. I can show your lordships if it becomes necessary, but basically the government had a right to terminate the lease. And if it terminated the lease, it then, I think, had the ability, there was a separate document which gave it a right to call back the site on repayment of all the lending by all the borrowing by NS from NCIB.
So the government, when it paid the bondholders, was in effect doing so on behalf of NS. Is this right? To discharge NS's obligations under the bonds, and the quid pro quo for the government was that in substance it got the site after doing that. That's right. Yes, thank you.
And we'll see that if we can turn now. If I say that this will take a little bit of time, but I think it is sensible to go through the financing documents or the project documents, starting with the memorandum of understanding, which is at page 256 of tab 1. Because I'm picking up my Lord Sales' point that basically, although the government this isn't spelt out fully in the documents, basically it was intended that the government was paying for the stadium. This was just a structure to arrange for it to be done, but basically the government was paying for the stadium. So if we look at the memorandum of understanding, which was entered into in January 1997, it had been based on documents, indicative terms submitted by ICS and CIB in just towards the end of the previous year. The committee will see the parties are Imbert Construction Services, which is referred to as ICS here. This is actually a different company from the ICS we're talking about. There was a new ICS substituted for this company, but nothing turns on that. Clico Investment Bank, CIB, and first, of course, the government at the top. And the recitals recite, the first recital recites the government's desire to construct the stadium. Recital 2, these are not numbered, but the next recital recites that ICS has submitted its proposal, and 3, that CIB had submitted a proposal, and 4, that the government had issued a letter in December the previous year awarding to ICS contract to design, finance, construct, lease, and lease back the project. And then the key terms are paragraph 1, project manager. The government hereby engages ICS to implement and manage the project and to develop the physical works based on designs approved by the government through a special purpose development vehicle, development company, hereafter called the Project Corporation, to be formed and owned by ICS. That company came to be NS. The project financing, clause 2, the Project Corporation shall engage CIB to arrange financing for the project using its best efforts and on the terms of the indicative document. The Special Purpose Company 3, the Project Corporation shall inter alia lease from the government the land on which the project is to be constructed, raise financing, make all necessary payments, and this is important, make all necessary payments to the ICS and the subcontractors and to CIB for the implementation of the project, and then lease back the completed facility to the government. And at the end, just Roman 6, I hadn't highlighted this, but just to draw attention to it, transfer the facility to the government at the end of the lease period or on full repayment of the financing, whichever is the earlier. So there we have the point. this MOU, this memorandum, it was in fact legally binding, and although it was intended to be replaced by the later documents, it seems to have continued to have a life within the later documents as well. It wasn't actually formally terminated. And then under the heading Consultants and Contractors, paragraph 4, ICS shall engage all contractors and consultants for the design and construction and supervision of the project. And financing facility 5, the total financing facility of the project shall not exceed $19 million and will provide for total design, construction cost of the building, payment of all fees, etc., etc. In fact, the 19 million went up to 23 million. This was then modified by a supplementary MOU, page 260, but I don't think it's necessary to take the committee to this. It does 3 things. It adds NS to the arrangements, NS having been formed by ICS as the project corporation. It substitutes ICS for Imbert Construction in the arrangements. ICS had been formed by Imbert Construction and was a specifically Grenadian company to deal with this. And it adds the Minister of Finance to the arrangements. So that we have that. Then we have the Act which gave statutory approval to the arrangements, which is at page 265 of the bundle. Again, well, let's just pass quickly through it. It provides 265, the Act, one sees the Act in May 97, and in section 2, it provides for the purpose of the development and financing of the Grenada National Stadium Complex, as proposed in Schedule A, approval is hereby given to the various agreements, deeds, and other documents to be executed by the parties as contained in the Schedule B, C, and D. And they contain the development agreement, the facility agreement, and the mortgage. If I can then turn to the development agreement at page 417, I'll need to take a little longer with this in the facility agreement. This was entered into a few days after the Act had been passed. The parties are ICS, who's called the developer, sorry, the Minister of Finance, referred to as the government, ICS, the developer, CIB, the financing agent, and NS, the project company. And it recites in the first recital the earlier indicative terms and the award of the project in recital 2 to ICS. And in recital 3 recites that the developer intends to finance, the developer being ICS, intends to finance the carrying out of the works by means of finance provided by the financing agent, CIB. And whereas the project company, that's NS, and the financing agent, CIB, have then entered into an agreement, the facility agreement, for making advances by the financing agent on behalf of the government through the project company to the developer or a consultant or supplier or other provider of goods and services in respect to the project. Here we see this point about the government ultimately financing it. I mean, in fact, the financing doesn't come from the government, although the government's going to repay it ultimately. And then the next recital records that it was agreed in the facility agreement that interim bonds would be issued by the government to the financing agent in respect of advances made under and pursuant to the agreement. Again, that's wrong. Bonds weren't going to be issued by the government. They were going to be issued by NS, the project company. And the next recital is that the government, the financing agent, and ICS have entered into a memorandum of understanding engaging ICS to implement and manage the project as hereafter defined on the terms and conditions therein. And then their reference to the supplemental memorandum of understanding. The key points, well, if we then move to clause 2, and we see here, this is an agreement by the developer on the subject to the terms and conditions of this agreement in reliance on the warranties in the agreement. The developer ICS shall develop and carry out the works, which is the project. So we have here we have an undertaking by ICS to carry out the works, and it's to be done in accordance with the contract. Now, there's an oddity here. If one goes to the definition of the contract, the contract means this is on page 411 at 119. Contract means the contract to be entered into by the government with the developer for the construction of the works pursuant to this agreement. But there isn't a contract between the government and the developer. But the development agreement seems to envisage that. What we do have is a contract between NS and ICS. We'll come on to that. Then in clauses 3, 4 and 4, the ICS agrees to proceed diligently with the works. In clause 4. And then in clause 5, we have agreement that ICS will finance the development of the works through the financing agent in the manner set out in the facility agreement. This is significant because it again underlines that it is ICS that's carrying out the works and needs the finance. But also important is the words through CIB in the manner set out in the facility agreement, because that reference to CIB indicates that CIB has a crucial role in the payment of the monies. The monies are going to come through CIB. If the monies were going to come from NS, one would expect rather different wording referring to NS. This clearly envisages the monies are going to come through CIB, and they're going to come in the manner set out in the facility agreement. And when we come to the facility agreement in a moment, we'll see that it does, in fact, envisage direct disbursements by CIB to ICS and suppliers. Then in clause 6, we have perhaps the most important clause. Under the heading consideration, it provides, in consideration of the agreement of ICS set out above, the agreement to carry out the works, the project company NS shall grant the lease to the government. So we have that. And then we have the government in consideration of what ICS has agreed to do. The government shall accept the lease, pay and cause the rent to be paid. And 6.4, concurrently with the execution of this agreement, enter into a contract with the project company, substantially in the form of Annex 2, and the project company being NS. So this appears to envisage that the government is going to engage NS to carry out the project. And if I can just take the committee to the annex. Actually, for this one needs to go to back to the copy of the development agreement in the Act. Forgive me, I haven't got the reference to hand here. Which envisages which is at page 364. This is Annex 2. Now, clause 6.4 has envisaged that the government is going to contract with NS on this contract, but this on this form of contract. But this form of contract is actually a contract between NS and ICS. So something has gone wrong here with the drafting of the agreement. The intention seemed to be that the government should contract with NS, but instead we have a contract which envisages a contract between NS and ICS. I'm not sure a great deal at the end of the day turns on this, except it shows that the documentation is quite loosely drafted. But what in fact happens under these arrangements is the government doesn't actually contract with anyone other than ICS to carry out the works. We have ICS engaged in clause 2 to carry out the works. NS is not engaged by anyone to carry out the works, but NS does in due course enter into a contract. This is what's called we've called the construction main contract in the terms of Annex 2. And then finally, within clause 6, we have clause 6.5, which is in which the financing agent, CIB, undertakes that it shall, under and pursuant to the facility agreement, pay or cause to be paid through the project company, NS, all monies due under or pursuant to the contract documents to the developer, consultants, suppliers, and other providers of goods and services. Now, we do say this is crucial from several perspectives. Firstly, and perhaps most importantly, it is a direct undertaking by CIB to, amongst others, ICS, given in consideration for ICS's promise to carry out the works, to use monies advanced under the facility agreement to pay ICS and other suppliers for work on the project. Now, the key point is that that shows that everyone was in agreement that this should happen and that CIB should commit to this. In effect, CIB was saying to ICS, with the agreement of NS, who was the borrower under the facility agreement, that it would use the monies advanced to NS under the facility agreement to pay ICS and other suppliers. Now, the appellant says that this amounted to or contemplated a declaration, at the very least, a declaration of trust over those monies and rights to the monies in favour of ICS. It was a contractual undertaking to ICS, and if necessary, could give rise to a trust in favour of ICS to deal with the monies, to pay them to ICS and contractors. Now,
sorry, Mr. Edith, may I just ask you about that? I mean, this is a contractual obligation, financing agent, to use the monies really quite generally to pay lots of different people. So I'm just struggling a little bit to see why you say that this is a contractual declaration of trust in favour of NH.
No, we don't say that. We're not saying that that in itself sets up a trust in favour of NH.
Sorry.
Sorry, and I know it can look like that because the judge at first instance actually seems to have been happy, although he relied upon a great deal more. He seems to have been happy that these clauses alone could establish a trust in favour of NH. Now, we don't need to, whilst we would say that there is an argument to that effect, we really don't need to pin our colours on that mast because we've got a great deal more to rely upon. What we're really saying is this arrangement is entirely consistent with what we say ultimately happened, because here you have the lender committing to ICS and NS that it will use the monies this way. So there's consent from ICS and NS that the monies should be used this way in payments to ICS and suppliers. Now, we would say, if it's necessary to do so, that is enough to give ICS rights to the monies. ICS could have demanded the monies, and one could also say that it's enough to give rise to a trust in favour of ICS. What we don't say is this alone gave rise to a trust in favour of NH, because we don't need to. We then have specific agreement in relation to NH. And we can see that if we started to say that this gave rise to a trust in favour of NH, one gets into all kinds of complicated arguments about, well, hang on, is there sufficient certainty here? Because, you know, who's a supplier? What if there are lots of suppliers? What if there are competing interests? What we say is what happened subsequently built on this and confirmed the arrangement so far as NS was to be concerned. I see Lady Arden is raising her hand.
Just a brief question. Would you also say that another analysis of 6.5 is that it constitutes an equitable assignment of part of the debt by way of to the people who subsequently can show that they are within that clause?
We would certainly say it constitutes, if the debt belonged to NS, we would say this is evidence of NS agreeing to assignment to ICS of its rights to the monies, because NS is agreeing with CIB that it can pay the monies to ICS or suppliers. And so we would go that far in relation to ICS. To say that it operates in relation to other suppliers, well, we would accept there is certainly an argument to that effect. What I don't really want to do is get bogged down in whether that is correct, because we just don't need to deal with that. I see Lord Sales is raising his hand.
Yeah, sorry, it's really a follow-up from my previous question. So you don't say that 6.5 is capable of supporting a declaration of trust in favour of NH, but I think you did say that it supports a declaration of trust in favour of ICS. And I just wonder how you can say that, again, because it's a general obligation on the part of the financing agent simply to pay through the project company a wide range of people who will be engaged in the project. What I'm struggling with is seeing why that constitutes a declaration of trust, or can support a declaration of trust in favour of ICS.
What we say is, I mean, we don't really need to establish a declaration of trust because we've got a contractual undertaking from CIB to ICS to do this. We would say that is enough. But what we would say is, when you approach it against the backdrop of the memorandum of understanding, against the recitals to this agreement, against the commercial arrangements, you've got ICS has undertaken to do everything on this project, to engage all contractors. It clearly wants to know it's going to be paid. So it wants to have a clear undertaking in the project documentation that means it will be paid, or that payments will go to those people it has engaged. And this does just that, we say. It assures ICS that it and the people it contracts with will be paid. And it is sufficient, if it's sufficient alone to look at it as a contractual obligation on the part of CIB, agreed to by NS, and following Lady Arden's point, as to the extent necessary, an assignment by NS of its rights to the monies, if it has would otherwise have rights to the monies. So we would say that it sets up a contractually binding obligation on CIB to use the monies these ways. And we would go a little bit further, my Lord Sales, and say that actually you can build out of that a trust in favour of ICS. But it doesn't. We don't have to establish a trust. The contractual rights are enough when we get to the assignment argument. I hope I've addressed the points there. So those were the first points I wanted to make about 6.5. The next point it shows that the party's intention cannot have been that payment would be made by CIB to ICS, or for that matter suppliers, merely as a matter of convenience, which is what NS have alleged. Their case is that the project documentation sets up a chain of contracts. NS borrows monies from CIB, engages ICS, who in turn engages NH and other suppliers, and neither ICS nor NH or other suppliers had any right to receive direct payment from CIB. And it was just agreed as a matter of convenience that payments would be made directly. But if this was the case, this clause 6.5 wouldn't have been worded this way. 6.5 is only explicable on the basis that CIB was undertaking to ICS to use the monies this way, to pay directly to ICS and suppliers. And the fact that reference is made to the possibility of payment being, quotes, through NS doesn't alter that. We would say that that possibility that's referred to there is an alternative to direct payment. So the obligation is CIB shall, under and pursuant to the facility agreement, pay all monies to the developer or consult suppliers, or cause to be paid through the project company, the same monies. It's an alternative. So the monies could be routed through NS, but CIB would remain liable for ensuring they reached ICS and the suppliers. And there might be circumstances in which it would be convenient for the monies to actually be routed through NS. And in fact, that option was not in fact utilised. The parties actually already agreed and set up arrangements for direct payment. But it would make no difference even if Clause 6.5 did envisage payments being routed through NS, because the parties subsequently agreed to do something which achieved the same practical effect. And the final point I should make about this is the reference to monies due or under the contract document sits perfectly well with that and with our analysis. Contract documents is defined as the proposal, this is in paragraph 1.1.10, the proposal, the award, the memorandum of understanding, this agreement. And this agreement is defined further up the page as the development agreement and its annexes. So it therefore includes the construction main contract between NS and ICS, which is the contract under which sums would fall due to ICS. And the sums due to other suppliers obviously didn't have to rise under the contract documents because no other suppliers were party to them. The expression should be read as applying only to ICS as contemplating, of course, that there will be sums due to other suppliers in due course when ICS engages them. So those are the relevant provisions of the development agreement. If I may turn to the facility agreement, and here I suggest we work from the start, from the version scheduled to the Act, which is at page 269. This was made on the same date as the development agreement between CIB and NS. It records that CIB has agreed to arrange a bond issue on behalf of NS to fund the project. And it must be seen in the light of the provisions of the Memorandum of Understanding, the development agreement, which explain that the financing is for ICS to carry out the project. And clause 2, under the heading facility, provides for, upon and subject to the terms and conditions of this agreement, the trustee agrees to make advances to and on behalf of the company or on behalf of the company up to a maximum amount, and then it sets out the amounts. The first tranche of $4,600,000 is to be advanced on at the outset on satisfaction of various conditions precedent, and then the remainder is to be advanced in equal quarterly tranches. The key points there are the trustee agrees to make advances to or on behalf of the company. Now it's clear that what is actually intended is that advances are going to be made on behalf of the company directly to ICS and contractors. And we can see this picked up in clause 3, which deals with purpose and utilization of the facility. And clause 3.1 provides that the facility should be used solely for the purpose of the project. But then 3.4 is important, and it provides that disbursements by the trustee on account of the facility should be made on the basis of proper invoices and documentary credits acceptable to the trustee. Disbursements in respect of work done and materials supplied in respect of the construction of the project shall be made on the basis of interim and other certificates of a quantity surveyor appointed for the purpose and approved by the trustee. So what we have here is provisions for CIB to receive the advances and then disperse them directly, subject to satisfactory provision of invoices and documentary credits. And this isn't in the least surprising when one looks and sees this against the backdrop of the Memorandum of Understanding and the Development Agreement, under which ICS is undertaken to carry out the project and engage all necessary suppliers. ICS needs the facility monies to discharge liabilities to those suppliers. And ICS, NS and CIB had agreed in the development agreement that CIB should make the facility monies available for that purpose by paying the monies to ICS and suppliers. So it really just confirms and outlines the confirms the arrangements we say flow from those documents. And it was a perfectly sensible commercial arrangement which addressed everyone's interests. The investors could be reassured that the loan monies would go straight to the suppliers rather than being routed through NS with consequent risks of misappropriation or otherwise. CIB had covenanted with ICS in the development agreement that the monies would be dealt with in this way, so it needed confirmation that in the facility agreement that it could do so. ICS had covenanted with the government to carry out the project and needed the monies. NS had covenanted with ICS to meet the costs of the project, and its liability to do so would be discharged by the monies being dealt with this way. And on top of that, the arrangement was also convenient from an administrative point of view, because it meant monies didn't have to go down the chain and then out. They could go straight from CIB. The only other points I should refer to in the facility agreement is the committee should just note that actually NH is referred to in the facility agreement, although it hasn't actually been engaged to carry out the works. It's referred to in the definition of builder in clause 1.13, and there's also a condition precedent at clause 4.2c requiring the builder provide a substantial performance bond before the loans can be advanced. So everyone knew at this stage that NH was in contemplation as the proposed builder. The other points I should deal with, I think, in the light of the committee's comments earlier, perhaps just the arrangements regarding investors. The way the bond issue worked is that CIB would obtain monies from investors prior to each advance. And on the date of each advance, NS would issue temporary debt instruments called interim bonds in the amount of the advance. And we can see that in clause 5.1 of the facility.
Sorry, Mr. Railiff, I'm sorry to interrupt you. I've got a technical problem. I've got no documents at the moment on my screen. I wonder if you could bear with me just for a moment while I try and sort that out. I can't follow obviously I can't follow the argument without the documents.
Ready now to resume, Mr. Railiff, if you're ready.
Thank you, my lord. I was just dealing with the arrangements regarding bondholders and drawing the committee's attention to clause 5.1, which provides for the company NS to issue temporary debt instruments called interim bonds at the on the occasion of the making of each advance. And the form of interim bond is in Annex 2 to the facility agreement. I'll give the committee a reference to that, but I don't think I need to take the committee to it. It's at page 284, and in essence, it comprises a promise by NS to pay the registered holder the sum stated in it, subject to the terms of the bond and the facility agreement. Now, those terms included the terms in the facility agreement as to security, and the security terms, to meet my Lady Arden's query about this, is at clause 5.5, which says that the company agrees to execute contemporaneously with this agreement, 1, a collateral deed of mortgage in favour of the trustee over the lands, and 2, a collateral charge over the performance bond to be obtained by the builder. And then redemption of these temporary debt instruments is to be by the issue of, these are fixed rate instruments, they're going to be redeemed by the issue of floating rate bonds in accordance with clause 5.2, which provides that on the first interest accrual date after the issue of the completion certificate, therefore after the stadium's been completed, permanent bonds are going to be issued. And those bonds are the form of those bonds is set out at page 290 of the bundle. I don't think I need to go to that. No, actually, it may be helpful. $290, yes, it may be helpful just to quickly turn to that. It's the trust deed, that's 290. Sorry, that's the form of the bonds forgive me, I don't have the reference to hand, but what I need to refer to is the trust deed which constitutes the bonds, which contains the terms of the bonds, and that is at 290 and recites the issue of the bonds. And again, just to pick up the point about security, clause 7 on page 301, we have a reference to the security which records the project company NS as either before or contemporaneously with these presents executed the mortgage over the site, and also actually a charge over the lease. And these are defined as the charged assets on page 291. Charged asset means the real estate of the project company known as Queen's Park, and the lease over which a charge has been created. So that is the security under the arrangements. And so the significance of all this is that whilst, as I mentioned before, whilst it's possible that there may have been some kind of trust in favour of the investors when they first advanced monies to CIB to be used in making a loan, they might expressly or pursuant to quis close principles have retained beneficial interest in those monies until used for making the loan. Once the loan was made, we say that any interest they might have had in those monies came to an end, and their rights were comprehensively set out in the bond instruments. And it's therefore correct to push the investors, the bondholders, to one side in terms of the analysis of the arrangements. They had provided monies by way of loan, which they were not intending to retain a beneficial interest in relation to. I see my Lord Briggs is raising his hand.
Yes, I mean, just standing back for a moment and looking at the facility agreement, the CIB is described as a trustee because from start to finish, it's a trustee for the investors, as I understand it. Initially, it's a trustee of the money pending advance. And the moment it's been advanced in exchange for either the temporary or later the permanent floating rate bonds, it's a trustee of the bonds. Does it not follow from that at that moment of transfer, NS becomes the sole beneficial owner of the money?
In the ordinary course of events, yes, it would be the borrower, and those monies would be held by CIB immediately following that advance, ready for disbursement to NS or subject to its directions. But we say that when you construe the initial project documentation, by which I mean not the construction subcontract, but the first tranche of documentation, there's agreement in that actually it's ICS for whom they are to be held for. It's ICS that matters, and NS is consenting to CIB dealing with the monies as ICS directs, and that makes complete commercial sense. And we then say you layer onto that, as a result of what happens subsequently, an arrangement which gave NH a direct right to the monies, because it was expressly agreed between NS, ICS, CIB and NH that the money should be dealt with by direct payment to NH without need to call on ICS or NS. That in a nutshell is the way we put it.
Thank you.
I think that's all I need to say about the facility agreement. The next document is what's been called the construction main contract. It's the agreement between NS and ICS, and it's a very short document. I don't think we actually need to go to it. It's at page, but if the committee wants to, it's at page 425. It's the very short document which we looked at earlier as an annex to the development agreement. And it's that document over which there's a bit of an oddity, because the development agreement envisages that actually there should be a contract between the government and NS, but instead there's a contract appended which is between NS and ICS. And it's just a simple contract by which NS engages ICS to carry out the works for the amount of the facility, 23 million. And then the final document, which comes into play later, all of the documents I've just been talking about are put in place in May. But then in June, we get the construction subcontract, That's the contract with my clients, with ICS. And that one needs to just look at the events that lead up to that, not just the document itself. It starts with a tender submitted by NH on the 1st of May 97. I don't need to go to it, but it's at 262 of the bundle of the record. There were then oral discussions between the parties, and I'll be coming back to these, but in which we say there was agreement for direct payment of NH from the facility proceeds. We then have on the 4th of June a letter from NH to ICS, which is at page 435 of the record, and we should look at that if we may. This.
Sorry, could you give me the number again?
It's 435. And it's from NH to ICS, draws attention to following issues relating to the above project. The first one is financing agreement. We require confirmation that the financing agreements have been fully satisfied or are in place. It was previously agreed that you would forward to our attorney a copy of the financing and other agreements. What this shows is that NH was very concerned to know that the financing was there in place, and at that point hadn't actually seen the documents. And then paragraph 2 is crucial. It's headed assignment of loan proceeds and says we require confirmation of the agreement that the money is due to us under the contract. That obviously is the proposed construction subcontract, would be assigned and paid directly to us from CIB. And there can be no doubt about what's being referred to here because of their heading assignment of loan proceeds. That's what's clearly been agreed that should be assigned to NH. And it's important because this letter confirms that there had been the agreement NH alleged.
Well, it's asking for confirmation.
Well, it's asking for confirmation of the agreement. It confirms there had been agreement and asks for that confirmation. Yes, my lord is correct, yes. But in a sense, the finding of the judge was that the agreement was complete. The oral agreement was complete. It was to the effect that, as we allege, the letter in asking for confirmation, I would respectfully submit, should be seen as asking for written confirmation. It was not an issue that had yet to be dealt with. It had been dealt with orally. The NH wanted to see it confirmed in writing. And what we see is the next day, this is at page 440, we see ICS responding.
Sorry, Mr. Ailiff, it's just on page 435 before we leave it. In paragraph 2, the agreement has a capital A, which looks as though it's referring to some specific document. Is that right? Can you help us with why it's written in that way?
No, I mean, I think, my lord, that is just, and it's not intended to refer to a formal agreement. It's difficult to see what agreement there could be, unless, I'm sorry, a good point, unless Mr. Elias, NH's principal, had been told that the agreement already existed under the initial project document.
See, I rather read that capitalized A agreement as a reference back to the financing agreement in paragraph 1. And so I was wondering whether actually they were just, in effect, saying either their understanding or their hope was that the financing agreement would provide for this. Could that be confirmed?
I'm not sure it matters too much either way. Just to take your point, firstly, the use of capital letters, I wouldn't suggest that's significant because we can see the capital A agreement and a capital C contract. It's just being used wherever there's reference to it, agreements. But it may, there are then, well, what is the substance of what's being referred to here? The gist of it is we understand there is agreement that we're going to be paid direct, and that is confirmed. Whether what had gone before was oral agreement, as the judge found, he found there was oral agreement they should be paid. But I think what my Lord Sales's point is, well, one could construe this as actually what had happened in the oral discussions is there had been reference to an agreement already existing, a formal agreement, which provided for direct payment of suppliers, and therefore NH are asking for confirmation of that agreement. But I would respectfully submit we should be living with the findings of the judge, which weren't overturned on appeal, which was that the oral agreement that preceded this was an oral agreement for an assignment.
Yes, thank you very much.
The words would be assigned are very important. They mean something possibly like would belong to and be paid.
Exactly. We say referring to assigned is clearly indicating a understanding intention that a proprietary interest should be passed. This is not indicative of an arrangement of convenience. It's about passing proprietary interest in the monies, which would be what commercially my client would have been interested in and concerned about. In a sense, though, again, the judge has made findings on these which haven't been overturned and aren't challenged on this appeal. So we have the judge's findings as to what the agreement was, which was that it was an oral agreement for an assignment of the proceeds of the loan. If I can take the committee to the page 440, which is ICS's response to this. It doesn't expressly refer to in the beginning of the letter to the letter of the 4th of June, but this is what's called the letter of acceptance. It's the letter confirming acceptance of the tender by NH, and it has it sets out various detailed provisions that are to govern the appointment of NH. The final one on page 442 is the relevant one, clause 17, which provides all monies due to NH under the agreement. Here we again have the capital A. The agreement shall be assigned and paid directly to NHIC. And we say that is obviously just confirming what has been asked for in the letter the previous day. The construction subcontract is then signed shortly after this. It's at page 445. It's dated 6th of June. I note in the arbitration award, the arbitrator found that it was actually entered into later in June, but nothing turns on that. It's got the date 6th of June. And
if you're, I'm sorry to interrupt, if you're going to take us through this agreement, then I think that's something we can do after the short adjournment.
And that's pretty much what I'm coming on to next. So.
Yeah. Very well then. But in that case, we'll adjourn until 2 o'clock.
Thank you.